Dear participants, a very warm welcome. As president of the European Law Institute, it is my great pleasure and privilege to welcome you all to this project kickoff webinar dedicated to the ELI's Detention of Asylum Seekers and Irregular Migrants and the Rule of Law project. In February 2023, the ELI Council took the decision to have a project aiming at updating the actual ELI project on detention of asylum seekers and irregular migrants in the rule of law, completed in 2017. The ELI 2017 output has been used in many instances, including to teach administrative judges in this respect. It has proved to be a fantastic source of information for anyone interested in issues related to detention of asylum seekers and irregular migrants. The idea of this kickoff webinar is to present the project and give an opportunity for the co-reporters to receive specific inputs before they finish the work. It is also a way to recall to everyone that the European Law Institute has what is called a Membership Consultative Committee, an MCC, which brings together any member interested in the projects. The MCC members can thus get a better understanding of the project, react to some drafts at various stages, and hand in their personal understandings or views to the secretary. Do not hesitate to become a MCC member, which you can become by sending an email to the ELI Secretariat. Our two project co-reporters, Maria Teresa Gil Bazao and Bostian Zalar, will start presenting their excellent project proposal and the impact of the former project of 2017. Maria Teresa Gil Bazao is professor of international law and international relations at University of Navarra in Spain. Prior to this, Maria Teresa was senior lecturer in law at Newcastle University and lecturer in international human rights and refugee law at Oxford University, and she has worked in Brussels during the first stage of the CEAS. Bostian Zalar is senior high court judge, administrative court of the Republic of Slovenia, president of the AARMG Europe, professor at the University of Ljubljana, lecturer at the Legal Clinics on Refugee Law, Faculty of Law, and a member of the network of courts and tribunals at the European Union Agency for Asylum, and ad hoc judge at the European Court of Human Rights. But before handing them the floor, let me remind you that the chat function has been disabled, but you can and should put all your questions to the exceptional panelists of tonight through the Q&A function that you will find below your Zoom window. Please do not wait until the end to pose your questions, but of course, we will answer your questions then orally at the end of the various presentations. But now let's start with our two co-reporters, Maria Teresa and Bostian. You have the floor, and I think Maria Teresa Gil Bazao is starting, so you have the floor now. Thank
you. Good evening to all participants, and good evening to colleagues. This is for us a very important moment, because it not only launches the project, or the update rather of the project on immigration detention, but also a new stage of the fundamental rights special interest group. So Bostian and I were asked to try and work on new adventures regarding this fundamental rights group. And we thought it was important and appropriate to work on that as part of the European Law Institute Axis on the Rule of Law. So this project is the first of hopefully many initiatives within the fundamental rights group, for which we are also very lucky to have a very good advisory board made of several members, including members who were already involved in this project in the first stage in 2017. So we thought the developments across Europe in relation to immigration issues and the use of immigration detention and the approach to immigration detention by member states required an update of the project and to bring in the case law, especially of the main two European courts, the Court of Justice of the European Union and the European Court of Human Rights, up to date. You can have a look and you can find all the information about the original 2017 project in the European Law Institute webpage. That original project that we are now updating is about checklists and standards which were originally conceived to facilitate the work of judges working on detention cases and lawyers defending the applicants with tools to uphold the rule of law. So it does contain standards and checklists on the 3 secondary European legislation instruments that contain detention provisions, administrative detention of third country nationals in the context of migration and asylum. And these are the Dublin III regulation, the Return Directive, and the Recast Reception Directive. We do know that the project originally has been very widely used and has been very appreciated by judges across Europe. But I will now pass the floor to my co-rapporteur, Judge Bastian Zeller, who can provide further details in relation to this. Thank you very much.
Thank you, Maria Teresa. Yes, when back in 2015, the project team composed of an expert from UNHCR, a lawyer from the registry of the Strasbourg court, an academic in the field of asylum, and 2 judges from France and Slovenia started to work on the 3 checklists on detention. There were a couple or so assumptions behind the project. And the first assumption was that there are many detention cases going on in Europe based on the Return Directive, Reception Directive, and Dublin regulation. And of course, many detention cases were going on outside the EU member states, in the contracting states of the European Convention of Human Rights. In a lot of cases, the Strasbourg court has found violations of various paragraphs of Article 5, but also violations of Article 3 of the European Convention of Human Rights concerning living conditions in detention, including in cases of detention of vulnerable applicants, even children. The next assumption was that judges in the contracting states or in the member states of the European Union predominantly use only national law without making references or without checking also standards from the extensive case law of the Strasbourg court and from the growing case law of the Luxembourg court, the Court of Justice of the European Union. For example, not before Magdi case in 2014, the referring domestic courts did not ask a single preliminary question from the standpoint of human rights law to the Luxembourg court. Although there was a lot of cases before the Luxembourg court on detention under the Return Directive starting from 2009 onwards. And we also know that the crisis of the rule of law exists, persists, and spreads over different fields of law if basic values are only declared on a paper but not taken seriously enough in legal proceedings. And we also took into account the time pressure that judges in the field of asylum-related disputes are faced with, and they do not have time to search for relevant criteria, standards that are scattered in the databases on case law of both European courts. But back in 2015, the European Law Institute also wanted to develop the first project in the field of administrative law, especially in relation to refugee situation in Europe. So these were reasons behind the project. And at our first meeting in 2015, I somehow speculated that each checklist would have maximum of 20 pages. and that work will be easily done. Because I said at that time that I know pretty much the relevant case law of the Strasbourg Court. Well, I was wrong, and we were all surprised to realize later on how well developed and detailed is the case law of the Strasbourg Court on detention and also of the Luxembourg Court. So the work was completed in September 2017. Apart from the 3 checklists on detention based on Dublin Regulation, Return Directive, and the Reception Directive, which are structured in sections 6, 7, and 8 of the Ely statement, there is also each checklist has its explanatory note. Then we added to these 3 sections, of course, introduction, where we explain the methodology of the project. Section 2 is devoted to the link between the rule of law and detention. We added also some statistical data on detention. And section 3 was included in order to explain the very specifics of the interplay between EU law, case law of the Strasbourg Court, and national law in the field of detention from the perspective of all 3 major actors. That is, from the perspective of the Luxembourg Court, from the perspective of the Strasbourg Court, and from the perspective of some constitutional courts and Supreme Courts of the member states. So each checklist has around 30 standards or criteria or principles, and these includes minimum living conditions for detention with special attention to vulnerable applicants in detention. Each standard starts with the provision from the EU secondary law. Then comes the eventual interpretation of the Luxembourg Court of that provision, and of course the corresponding provision of the Charter. And then comes the eventual interpretation of the corresponding rule or standard of the Strasbourg Court. All references are in the checklist in the footnotes with indications of concrete paragraphs from the judgments of the Luxembourg and Strasbourg Court. So no other reference is added. No academic source are used because we wanted to collect and select only part law. So this means that when a judge gets a case on detention and must decide the case in 3 days, he or she will normally take his national law into consideration as a starting point, but the respective checklist helps him or her to verify whether national law is in line with the case law of the Strasbourg Court and Luxembourg Court, and helps him to interpret national law in line with the European law. For example, in my experience, an average case on detention arises 1, 2, rarely 3 relevant legal questions, and it should be easy for a judge to find the respected standard in the checklist. These are questions such as, for example, what is the significant risk of absconding linked to the purpose of securing transfer procedures? What should judicial control over the quality of law on detention consists of? Is there a right to information and a personal interview before the detention order is issued? What is the meaning of a requirement of individual assessment? What is the due diligence requirement? Then right to free legal assistance and representation. What are standards of the right to speedy judicial review of the lawfulness of detention? What is the scope and intensity of judicial review? How can be applied restrictions on the right to defense and on equality of arms based on national security? Then right to compensation, for example, in the case of unlawful detention. Right to reason judicial decisions and their enforcement. So, as I said, there are around 30 standards or criteria of this kind in each checklist. But in the final part of the checklist, there are also standards on living conditions in detention. For example, under which condition children can be detained, what are the minimum requirements for the living conditions in detention in general. So the Ely statement on detention was published in September 2017. And from that time onwards, both European courts did not change their practice. So checklists are still useful for judges and lawyers, but checklists must be updated because around 13 new judgments of the Luxembourg Court were issued and about 50 new judgments of the Strasbourg Court need to be checked whether they add anything new in the existing checklists. Updating will consist of, in some cases, we will just add fresh reference of the Strasbourg case law in the footnote, for example. In some other cases, we will have to add few sentences to the existing standard in the checklist because the Luxembourg court had developed further interpretation of the existing standard. And the third option will be that we will have to add a new standard. And this will be the case, for example, when the Luxembourg court developed interpretation on a particular material ground for detention. And I'm sure that Strasbourg court developed some additional and more detailed standards on conditions in detention for vulnerable applicants, especially in particular places like transit zones or hotspots. It is difficult to predict the timeline, but we already start working. And I think that the major part of work will be done during the summer break. I would like to thank members of the project team and members of the advisory committee to express an interest to take an active part in this updating project. And I count on a strategic approach to dissemination of updated checklists in the beginning of the next year or at the end of this year. I thank you very much for your attention.
Thank you very much to both of you for presenting, the impact also of this 2017 project that is now the object of this update. And I think for the ELI, it's the first time that we have an updating of our initial output. And here, as you said, it makes perfectly sense because having taken into account all the court decision of the European Court of Justice and of the European Court of Human Rights, it means one has to check and update, especially as you underlined, Bastian, the importance of reacting very quickly in practice. And so judges need to have that at hand. So for those who didn't know about the existence of this checklist, I mean, the first edition, you'll find it in the Q&R section and the questions already answered because the Secretariat put the link to it. So of course, it's still usable, but of course, the new one will certainly be much better in terms of updating on current case law, as you suggested. Now, of course, to understand the impact and the importance of this first output of 2017 and the importance of the new output, I'll have now the pleasure to give the floor to Fabienne Baxevanos. She's a legal officer at UNHCR representation for EU affairs in Brussels. And in this capacity, she heads the legal team and coordinates UNHCR's judicial engagement in Europe. So it's the perfect person, of course, to appraise this work. And in particular, she's always in engagement with the Court of Justice of the EU and the European Court of Human Rights. She also leads on UNHCR's work on specific files of the CEAS and PACT proposals, and in particular on asile procedures and qualification for international protection. Now, she will give some reflections on the project's strengths and innovations from the UNHCR point of view. Fabienne, you have the floor.
Thank you so much. Thanks so much to the organizers for having me. It's a pleasure to be with you tonight. Thanks a lot to Eli for facilitating this project, and in particular, thanks to the project leaders, Maria Teresa and Boss Chair, for having having done all the groundwork already, because I'm coming very late to this project. I'm a new member, but it should be emphasized that the monumental work, this big task has been done, and it's really a beautiful product, a very impressive product of legal research, and I'm not surprised that it has been taken up very frequently by many courts around Europe. So you've introduced myself already. I work for UNHCR's office in Brussels, work on what we call judicial engagement, but also on the pact. And I saw there was a question on the pact, and I'll mention that also in a second. I'll just make very brief remarks today, focusing just on three things. I'll mention a word on context, and in that regard also mentioning the pact and what we have in terms of legislative new proposals. Then I'll say a few words about judicial developments, and then closing off with what UNHCR's perspective on these is and how we're engaged on those issues. So first on context, it's very clear that detention is an increasingly important, controversial topic in EU asylum and migration law and policy. And that's particularly true in recent years when we had the Commission proposal for a new pact on asylum and migration in September 2020. There was an understanding that detention would become more prominent, especially at the EU's external border. Under this piece of proposed legislation, there is the suggestion that during an initial screening phase and then later on during border procedures, there would be movement restrictions. And in many cases, this would mean detention. There was a lot of debate in recent years how this could be implemented in a lawful manner. And at least parts of the Commission proposal have now also been modified by both the European Parliament and the Council. But in general, I think we as UNHCR, we had quite a bit of concern over a lack of harmonization because parts of the proposals suggested that detention would be ruled by national law and not by EU law. So that was quite a serious concern we had. Around 1.5 weeks ago, there was quite a significant development, namely the Council adopted its general approach on the border procedure, but more generally on asylum procedures and the new Dublin regime. And it looks like, from what we see now, that detention will be more standard, will be more frequent. And if it goes as the Council would have it, also families, including those with small children, would not be exempt from those border procedures, which would entail de facto detention in many cases. So this is just for the context to emphasize how important it is to have very good and clear guidance on the applicable law. Because what I see, and this brings me now to the judicial developments, is that practice is very bad in many member states. First, what we see is that practice diverges significantly. So we have some member states where asylum seekers are detained on a regular basis, sometimes for the initial period, but sometimes also for the initial period of registration, I should say, but sometimes also for longer periods. But overall, and some member states don't do that, obviously, and that's good like that. But overall, the trend goes towards more detention, which is worrying. Second, and I do think we have maybe some judges also in the audience. Evidently, judges in all member states play an absolutely crucial role in reviewing detention and then looking at the lawfulness of detention, but not in all member states they have the powers to do so without restrictions. In some member states, perhaps there's legal issues. In some member states, there's resource issues. And it's good that the Luxembourg court has clarified in a few judgments that where the national law does not allow the national judge to properly exercise this responsibility in reviewing detention and also to lift detention where it is found to be unlawful, then such powers can be derived directly from EU law. A third concern that we have is that European case law has not always been extremely consistent and very easy to understand. And that concerned both the question of what is detention but also, of course, when is such detention lawful? And I'm always speaking, of course, about detention of asylum seekers. And on both of these questions, we saw quite interesting evolvement from the European courts, and also a very interesting dialogue between the two European courts. But we also saw a lot of confusion and a lot of differing interpretations, and where the case law is not 100% clear and easy to understand for everyone, there will be challenges. And it's difficult to lead discussions with authorities if there are difficult and or differing interpretations of the legal precedents. And for all of these reasons, we think that this very comprehensive and, as I said, very impressive, monumental piece that this ELI guidance detention checklist is, that's very welcome and much needed. And I'd like to emphasize that it's not just a textbook style collection of case law summaries. It's really a very analytical piece of work that works out the standards that apply, that derive from this case law. And it's really a practical guide on how to apply such case law detention. Boston mentioned it already, a bit the content of those guidelines. But for us, it's just excellent to have the checklists that are also structured very well. So there's a nice delineation between detention under the Return Directive, under the Reception Conditions Directive, under Dublin, where sometimes the case law is not the same because the legal texts are not the same. So that makes sense. And also, what is a great feature of the detention guidelines is that national law is represented. So in our view, it's not only the two European courts that should be listened to, but also the national courts, which often develop standards also in more detail, because they are the ones who apply the law on a daily basis. So the content is very rich of these guidelines, and it's quite unique, I would say, and therefore it's just excellent that it has been picked up by legal practitioners to a great extent. I'll just finish with some words on what UNHCR does in this area of judicial engagement on detention. And the first and maybe most prominent or most visible thing we do is to write interventions before European courts. In the area of detention, it was mostly the Strasbourg court that we engaged with. And there, in recent years, we've intervened as a third-party interveners, an amicus curiae, as friend of the court, in several cases against Hungary and Greece. It was mostly Hungary and Greece because there we felt the detention practices were most problematic. We did cases such as RR and others v. Hungary, followed up also by Ilyas and Ahmed v. Hungary, concerning different factual situations and with different outcomes also by the court. We did a case on detention of children in Hungary. We also did a case on detention of children, which was called protective custody in Greece, where children were systematically detained in police stations under the heading of protective custody, which we challenged as unlawful, and a few other cases. But mainly, we used those detention cases to not only provide a description of how the situation on the ground is in Hungary and Greece, which we're happy that the court regularly also picks up, but also to repeat our longstanding views on detention under the ECTHR in these cases. And finally, apart from those public and written submissions, we work with the judiciary on detention cases and many other things, but also detention cases, sometimes more informally, sometimes ad hoc, depending on what judges need. But I want to just mention there are these forms of cooperation when you're faced with a case maybe on detention and you would require information on a certain country of origin or country of transit. There are ways that UNHCR has cooperated in such cases. So just to conclude, again, I think this these guidelines are excellent, are valuable, are incredibly rich. It's probably going to be quite a lot of work now also to update all of that. But as I said, the monumental task has already been done by my project leaders. So if any of the people on the call haven't had a look yet, I'd encourage you to do so and use it. I hope it's going to be useful in your daily work. So thank you very much.
Thank you very much also for giving the context of the evolution, and we might come back on that during the Q&A session, which will follow the next presentation. But thank you very much, Fabienne Baxevanos, for these really interesting insight comments. I come now to our last but not least panelist for tonight. She's Sophie Piquet, and she's the immigration coordinator in the registry of the European Court of Human Rights in Strasbourg. She joined the Council of Europe after having worked for the UN High Commissioner for Refugees, and she worked as a lawyer at the registry of the European Court of Human Rights and became responsible for the unit in charge of processing all interim measures for the ECHR. Since February 21, as immigration coordinator, she's responsible for leading a transversal strategy for processing all immigration cases at the court. And so I could say she's really the best place to understand the evolution of this case law, at least at the European Court of Human Rights, and therefore to give us some reflections on the project's strengths and innovations from the European Court of Human Rights point of view. Sophie, you have the floor.
Thank you very much. Good evening to all of the participants and the previous speakers and you. I'm very grateful to Eli to have invited me here on this event, which deals with what for us, at least in Strasbourg, has become really a critical topic. And I also feel privileged to have had access to the checklists, which, like Fabian just said before me, feel like a monument. I agree with the adjective she used. Now, here I would like just to say a few words in background to give you a little bit of perhaps a taste of the atmosphere in Strasbourg on detention of migrants. I will also make some comments on the strengths and innovations of the project as I've been asked to, and perhaps I will try, not without aiming at being exhaustive because it will be impossible here, but at least to give you some ideas about the trends which we see coming up in the case law in Strasbourg. I mean, the background, you have very kindly introduced myself. Now, I'm actually I was actually called 2 years ago to try to lead a project in the court to enhance coherence in the case law on immigration. And this has become a transversal thing. So all the 46 member states or state parties to the convention are concerned. And my team is dealing with all the immigration cases in the court. To give you an idea, this at the moment represents 2% of the pending cases in front of the court. So we see a lot of things, of course, and they go through us. And our effort is really to ensure coherence and consistency, because our judges and our managers have really tried to compensate this tendency to divergence, which we can see happening. Now, in the context, in the migration context in Europe, which we all know, one of the most complex issues really has come up, which has come up recently, including during the pandemic, is detention, clearly so. And when Boston said that thought it would be a simple work, and it turned out to be very complicated and complex. I must say I can understand that very well. Now, first of all, I would like to say about the strengths and innovations of these checklists, which were published, that I was amazed by the exhaustivity and thoroughness. I think this should be underlined by all means, because starting from Roman law to modern instruments, we have here a comprehensive document which deals with all aspects of the things, all the aspects of the thing, and this is rare. I mean, I would like to underline that. It's very rare. From what we see coming up in Strasbourg, the burning issue for lawyers and judges is clearly how to deal with the interplay of EU law, European Convention of Human Rights, and national law. And here I cannot be, how to say, enough enthusiastic about section 3 of the checklists, which deals with this issue in a very innovative way, looking at it from the different standpoints. And this is really something unique and precious, which I would encourage every judge to look at, because it also sets the tone for the rest of the document, which really gives the keys. I think as a lawyer or as a judge, often looking under time pressure, like Boston mentioned, for very specific items or very specific questions, and looking at them from the different angles, EU, European Convention and national law, finding an answer, a unique answer, or the elements of the answer as well, as such, in one document is rare. Now, about judicial dialogue, this is something, of course, the court in Strasbourg has encouraged since the beginning, I would say. And I cannot talk here about all the conferences which have been organized, but also about the superior court networks which exist in the court in Strasbourg, and where the importance of convergent use of case law of the court in Luxembourg and the court in Strasbourg is mentioned all along. And this document really contributes to it. Now, I know that if the structure of the document relies on the Dublin III regulation, we don't know whether that will be still relevant in the near future. But I find also that the structure of the document is flexible enough to be updated, and updating is really certainly important. Now, if I can say a few things about what we see coming up in the case law in Strasbourg to conclude, I've noted down 6 main areas where things actually pile up, I would say. And I'm talking here about recent cases, but as well as pending cases. The very first item, I would say, is applicability of Article 5 of the Convention of Human Rights to certain situations, and in particular 5.1f. Applicability has been confirmed by the court in airport transit zones, land border transit zone, reception centers, and hotspots facilities. But we see it more and more coming up that enlarged applicability of this provision is questioned and invoked in order to justify migrants' detention. And we have new cases coming up. I have the references at the disposal of a project team. I'm not going to dwell into details here unless somebody is really interested. But we have cases against Hungary where the court has decided recently, for example, that Article 5.1f of the convention would not be applicable, and therefore the state in question, Hungary mainly, was condemned by the court because persons who had a resident permit on humanitarian grounds, which was in line with national law, were detained. So there is this tendency of trying to make Article 5 less applicable, more applicable in order to justify the detention of migrants. Now, the second trend is certainly the detention of migrant children, be them accompanied or not. And again, I will be at the disposal of the project team with a number of references which are clearly coming up. And one of the most known and complete is probably SF and others versus Bulgaria. Detention of vulnerable persons is also another issue which is clearly at stake. Vulnerable person, any kind of vulnerability, I would say, be it for age, health condition, gender, but also, for example, we have a number of pending cases concerning pregnant women and women with newborn babies in closed hotspots during the pandemic. Those are yet to be decided. Detention and Article 3 in extreme situations, was mentioned by Bosnian earlier, and it is coming up again because detention often triggers not only the Article 5 of the Convention, but also the article on the prohibition of ill treatment and torture. Now, in conclusion, I would like to conclude now, and I would say, I think I made it clear that in my view, this is a very important document, which clearly needs updating, not only with a new and fresh case law, but also, and probably mainly, it needs to keep this intertwined approach between all the sources of law, be it EU, European Convention, national law, which is really key to have a convergent approach. I found, and if I may finish on a personal note, I found the document very useful, and I would right away, as it is, suggest it made available on the our platform, which is available for our judges and registry members for direct use by them. And of course, we can have the updated version put there as well. But I would ask for your authorization to use it on our platform immediately. So I'm personally available to answer the questions of the participants, and then I thank you very much for this opportunity.
Thank you very much. Thank you very much for this very positive also assessment of the 2017 output, but also for giving us some of the trends that will be necessarily integrated in this update. And I think that's already a great insight into the work that will be finalized by the team during, as we have heard, during the summer. So thank you very much, Sophie Piquet, for all this. And of course, we will also discuss your last suggestion at the end. It is now time to answer some questions that we already got, but of course you still are able to put some questions in the Q&A section so that our panelists can answer them. So, and for the time being, I see 3 questions. The first one was more or less addressed already by Maria Teresa, Fabienne Barcevanos about the pact, but there was whether the new EU deal on irregular migrants and refugees will be integrated into the report. So I don't know whether Maria Teresa or Botian Zalar or Maria Teresa Gilbazao, whether you want to say something about integrating also, at least in the notes or in the illustrations, some of these new trends as well, or whether that is kept outside because you are focusing on the case law mainly. I don't know who of the two of you wants to answer. Bosien?
Well, maybe we will put some information in the introduction, because checklists are the aim of the checklist is to help judges in applying and interpreting the existing law which is in force. But in the longer run, of course, when if the law will change, then we will have work again. Although it will be an interesting situation, since we will have a lot of case law of the Luxembourg Court and Strasbourg Court on one side based on the primary EU law, and having then provisions from the secondary law, which will of course will have to be in line with the primary law.
Yeah, thank you.
That would be my very first reaction.
Yeah, of course, and I can imagine that while preparing the revised version, you might realize you need to address some of the issues or not. But yeah, thank you very much for that. Then we have two questions by Tamas Molnar, who is also a team member, and so he will have also hands in the project. So it's more to already suggest some points, but he said that the updates, he believes, will mainly focus on case law, as you said, Bosien and Maria Teresa, of the two European apex courts. And he was saying that almost no black letter rule has changed, and that's also what you say. And then he also went on with, of course, the reception of the conditions directive and return directive following 2017. Now, maybe linked to that, because I do not exactly see the question, but linked to that, I'm just wondering, because I saw we have also some English judges in the people listening to this webinar, whether the fact that now you will have also some issues for non-EU member states, but who are member of the Council of Europe, and therefore there might be a different tension as for those who are both member states and member of the Council of Europe. So is that addressed in a particular way, and especially for the new edition, will that be stressed in a more intensive way, because maybe the tension is more important? As you can hear from my question, I'm not a specialist of asylum law, but maybe not everyone listening to this webinar is, and so that might be an important point to address. I don't know, Maria Teresa, do you want to maybe answer that question so you have a chance?
Thank you for the question. It seems that the structure of the existing statement that we are seeking to keep already distinguishes between the case law of the European Court of Human Rights and the Court of Justice of the European Union, and therefore the standards that arise from each court are very well identified. So judges in in Council of Europe jurisdictions will be able to use the Strasbourg case law. But in any case, it is always useful to be aware and find about best practices whether they arise in a particular jurisdictional context or not. So of course, all EU member states are members of the Council of Europe, but members of the Council of Europe who are not EU member states or who are no longer EU member states would nevertheless be able to benefit from those standards arising from the Luxembourg Court, especially when those standards may be higher sometimes or may provide specific detail that has not been covered by the Strasbourg Court.
Thank you very much. Sophie Piquet, you wanted to add something?
If I may, yes,
Yeah, sure.
thank you very much. Absolutely, I cannot agree more with what was just said. I mean, the Strasbourg Court, as we know, of course, sets the minimum standards, but always looks at what exists in the EU. So you will find in the judgments of the court always reference to the existing standards in the EU law, and most of the time they intertwine here again. So of course your question is very relevant in the sense that there is coming and going everywhere, and all this legislation is intertwined. I cannot find a better word at this stage, at this time of day, at least. but unavoidably, the standards have to be connected, and this is what I was trying to say during my presentation. Thank you.
Thank you very much. Fabienne Baxevanos from UNHCR.
Yes, thank you. I mean, very much into the same direction. I think especially in the case law on detention, but also on other issues concerning asylum seekers, we've seen a very intense cross-fertilization, if you want to call it that way, between the Luxembourg Court and the Strasbourg Court, and sometimes also national courts. And thanks to Sophie Piquet for also having highlighted all these various dialogue forums, which I think are very needed, really excellent, because in such an important area that is so fundamental rights sensitive, any divergence and disharmony really hurts and can be ping-ponged from one state to the other. So the more harmonious, the better. And I'm very glad to see also these cross-references between especially the European courts. So I think UK judges or other non-member states do very well also at this other section and vice versa.
Thank you very much. That leads me maybe to a second question until maybe more question comes from the public. Bastian, you mentioned that, of course, you take into account the two main courts, but also some of the domestic courts and position. Now, we have spoken about this intertwined and cross-fertilization, but it's also to some extent a variation from one domestic to the other domestic legal system or court system. So I was wondering, to your perception, are these differences really so important when we understand that on a higher level there's already a lot of cross-fertilization, and that one would have the impression that the main standards are already there, and that national courts cannot add a lot to it? Or is it just linked to the fact that the cultural perception and understanding varies, and therefore the implementation varies?
Well, we in the existing Ailey statement on detention, we included maybe 4 or 5 seminal judgments of the highest national courts in order to show examples where the national courts had really intervened substantially in the situation, for example, in Germany, in Austria, and United Kingdom, back in, I think, 2015. but the question, while listening to the previous speaker, the question is perhaps whether we should not include these, the most important national judgments in some standards as a reference point. That's a thing that we will have to discuss within the project team and with the advisory committee. As regards the differences, Fabian has mentioned or pointed out that there are differences between the Luxembourg and the Strasbourg court. There are differences, yes, some differences, but speaking as a judge who adjudicate detention cases, these are not such differences that would make my work more difficult. As Sophie mentioned, the Strasbourg Court gives minimum standards. And in all these three cases, detention on return, Dublin, and reception, we are applying EU law. So EU law is on the first stage, and Strasbourg Court gives further, let's say, clarification, but the legal source is EU law in conjunction with Strasbourg case law, because not in all aspects, Article 5 of the European Convention corresponds to Article 6 of the Charter. For example, there were differences as regards the detention in Hungary, FMS case of the Luxembourg court in comparison to Ilyas and Ahmed. But these are differences that have the logics, its logic, and for national court, it is not impossible to navigate between these if a national judge applies the methods of interpretation that are applicable under EU law. So I think that the checklists help judges in this way too. And I also think that despite Brexit, I think that the UK judges might find some relevant inspirations also in that part of the checklist which cover Luxembourg case law.
I see. Thank you very much. And of course, coming from Switzerland myself, we are part of Schengen Dublin, and therefore, even not being part of the EU, it's very important in Switzerland as well. So it goes beyond, and that's what I want to stress, certainly beyond the EU member states. I see if Fabienne, you want to react, you're welcome.
Thank you very much. Just on your question, I think domestic case law is really important. I don't think that everything has been said by the European courts, and therefore there is nothing kind of left to adjudicate anymore. And I think for two reasons. First, some of the very detailed technical issues might not be dealt with by the European courts because they're down to national procedural rules. So I think some of these more detailed things are really then for the national courts to adjudicate, and they kind of give more meat to the sometimes very abstract obligations that, for example, the Strasbourg court has to interpret. And second, sometimes the law, and here I'm thinking of EULA, doesn't regulate in such detail, and then the CGU would not be able to give a very, very detailed answer, because sometimes the law leaves discretion to member states, or in particular where issues are very, very sensitive, maybe also the Luxembourg court might not want to give a very detailed explanation or interpretation, which would bind member states too much. I'm thinking here particularly about national security cases. So I think in terms of the kind of the practical meat that can be added by domestic courts, but also maybe some of the more sensitive issues where the law is not so descriptive. In those cases, domestic courts, and in particular the higher courts, can be really valuable.
Thank you very much. I see no further questions, so let me just try another one, and then maybe if there are no other points, we will just have a last round among the panelists. Bostian, you mentioned that as long as judges apply the methodology of interpretation of EU law, you know, the outcome would be fine. I was just wondering, I know the checklist, of course, and I know you did not really integrate a part on interpretation and what would be the kind of checklist of interpretation methodology. But listening to you, I was just wondering, would that not be something that might be also important for judges? Because if they get the substantive answer, but then fail, if I may say so, in applying the interpretation methodology, that might be a bit problematic. What do you think?
That's a very good remark. Maybe we could squeeze this remark into 5 basic principles of the application of EU law, and to put them in the maybe in section 3, which was so well highlighted by Sophie. I'm glad that you mentioned this section. So yes. We will discuss this within the project group. I can give you one example with the issue of a necessity test. For example, necessity test under the EU law is necessary, is part of law, which is not the case under Strasbourg case law. But if principle of proportionality or necessity is regulated in national law, then Strasbourg Court also imposes this principle. So this is the interplay. So if I'm a judge of the member state, I have to apply necessity test. If I'm a judge of the non-member state and we have a necessity test in the national law, I have to apply it also from the standpoint of the Strasbourg case law. So everything is manageable.
Thank you very much. Thank you very much for that. And in the meantime, we got one further question. So maybe I put it to you. It says the EU has a number of legislative acts on those issues, while the European Court of Human Rights applies the European Convention on Human Rights, that as such doesn't deal with the refugees and international protection seekers, but applies a so-called par ricochet understanding of Article 3 European Convention of Human Rights. Now, the EU aims mainly at establishing mechanisms related to the assessment of the member state that bears responsibility for the asylum request. Do you think these discrepancies between respective approaches might endanger the protection of individuals involved? And maybe I ask you as a judge, or maybe Sophie Piquet or Maria Teresa might also react. Yeah, Maria Teresa, you may start.
I was actually going to, I think it is better for Bostian Zalar as a judge
to intervene.
Sophie Piquet. I would say nevertheless that wouldn't so much be an issue because of the concerns and remarks that we have already addressed. But I think it is better for them to answer that question. Thank you.
So,
but I think you already did, Maria Teresa, because I agree with you. It's not a problem.
Okay, so no problem. So maybe we will have a last round, and may I give the floor maybe first to, we will go the other way around. So beginning with Sophie Piquet, and then the other way around to give you just 1 minute, maybe for a last sentence or a last comment you want to do. You're free, of course, to do whatever you want to say.
So much freedom. No, I just at this stage I'll just be enthusiastic to see the update, honestly. Also, of course, we all know that the CERS is developing fast, so that's something which, of course, is topical. As for the Strasbourg Court, and if I may come back on what was just said, of course, it's not a problem. I mean, as I don't know how many times I've read this, but the convention is a living instrument and is adapting to all the situations which are coming up to the court and which are raised by individual applicants. And as it was said before, of course, the court doesn't go into the little tiny procedural details, but the issues which come up to the court are essential and are the main ones, and the court has already always dealt with them. Now, on these checklists, I really, as you noticed, I'm sure that it can be an instrument of convergence, and as we have all underlined, this is an essential item to keep, a characteristic of European law, which is essential. I think I will finish with that.
Yeah, thank you very much. Fabienne Baxevanos, UNHCR.
Thank you. I mean, starting maybe from this last question, I mean, of course, there's a big difference in the legal toolbox that is the ECHR and the SEAS. The SEAS gives judges also a very nuanced, fine, technical, detailed instrumentarium of how to solve asylum cases, and not just Dublin, like the question suggests. There's very detailed rules on procedures and who qualifies as a person of international protection, on how these people should be accommodated while their procedure is ongoing, and so on and so forth. So that is a very detailed, nuanced instrumentarium, while the ECHR is, of course, open-ended, perhaps abstract, which gives a large spectrum of interpretative freedom. But as Sophie Becquet also mentioned, the court has a very detailed case law on these issues, and on detention, there's many cases and a lot of standards and precedent guidelines that derive from that case law. So I also don't think that is a problem. It's two different tools, but both have their purpose. And if, as it's currently the case, there is this dialogue, this mutual reading of each other's decisions and keeping in mind others' findings, then I think there can be a beautiful interplay. And coming now to the detention checklist, they can of course play a big role also in facilitating this dialogue, in making very clear what standards apply, from which authorities they derive, in which situations they're applicable, and really guiding judges at the European but also at the national level in how to apply all of these precedents. So I think, again, it's really an impressive piece of work that has already been produced, and I hope it will continue to serve many judges and other legal practitioners in deciding correctly on detention cases, which after all involve one of the most significant freedoms that we all enjoy. So thank you very much.
Thank you very much. Now I give the floor to Bostian Zala, and then last at Maria Teresa. So Bostian.
Well, I would say that this enthusiasm of the speakers obviously means that we will have more work than we thought at the beginning. Although it's, of course, I'm very content to hear these words of appreciation. And we will definitely take on board the proposals as regards the a little more attention to national judgments of the highest court, and also to add a few things in the section 3 on the interplay from the standpoint of the basic principle of duplication and methods of interpretation of EU law. And I would also very much agree with Fabienne that this will be a further step forward, or a small contribution to build judicial dialogue and also mutual trust within the European Union, and I'm very happy and positive about the project team and advisory committee, and I look forward to this work. Thank you.
Thank you very much, Bastian. Maria Teresa, as co-reporter, you have the almost last word.
Well, I wanted to thank everyone for their participation and contribution today, all the speakers, the team members, the advisory committee that are making possible this project, but also the initiative of the European Law Institute and of its president to bring to the table the need perhaps to undertake an update and to consider broader issues of fundamental rights in Europe at this point in time. So as Pascal mentioned earlier on at the beginning, there is an opportunity for members to contribute to this within the structures of the project. And I think we would very much welcome contributions on this. And going back to the point made earlier by Sophie Piquet in relation to putting the statement on the Council of Europe website, I'm sure that is something that we could facilitate at either this point or later when the statement is updated. So we look forward to developing this update of the project at this point that we are launching it and onwards. Thank you.
Thank you very much. Thank you very much. And I think this panel was really very interesting also to see that we are already looking at the third edition potentially because things are evolving. But let's first concentrate on this second edition. I'm sure it will be fantastic. And so I'd like to thank first the two co-reporters, Bastian Zalar and Maria Teresa Gil Bazaro, for taking on their shoulders this update project, but also for presenting it and being here today. And thank you very much to Fabienne Baxevanos and Sophie Piquet also for giving their insight, giving us some better understanding of the importance of this project and also of making us eager to see this second edition because the first one was already so important. So thank you very much. Thank you to everyone who attended this webinar. I wish you all a wonderful evening, and we look forward to the output as soon as it will be ready. In the meantime, I wish you all the best and see you soon. Thank you very much. Bye-bye.